Good evening, ladies and gentlemen, and a very warm welcome to each one of you for today's discussion on dispute resolution in the medico-legal sector. I thank you for taking time from your busy schedule to deliberate on this topic for the benefit of the medical and legal community. We are delighted to have all of you among us. My name is Gandha Sahu. I'm a lawyer and mediator. I'm paneled with the Center for Mediation and Conciliation at the Bombay Chamber of Commerce and Industry. By way of a short introduction, the Center for Mediation and Conciliation provides a much needed neutral institutional platform for resolving disputes and wishes to promote an efficient, sustainable, and solution-oriented dispute resolution process for resolving all kinds of disputes. As a mediation center, CMC is associated with the High Court of Bombay and the City and Sessions Court of Mumbai, and is recognized by the Government of India's Ministries of Law and Justice and Micro, Small, and Medium Enterprises. We are happy to announce that we have concluded around 200 cases received from the courts and from our members from various fields, and hope to present ourselves at the forefront of all subject matter dispute resolution. I am pleased to introduce you to my co-panelist today, Dr. Lalit Kapoor. He is the President, Federation of Associations of Medical Consultants of India, FAMCI, Medical Director of Shakuntala, and the Medical Director of Shakuntala Memorial Hospital. Dr. Kapoor has been at the forefront to ensure that medical legal disputes are addressed with fairness and the rights of the parties involved are protected. I invite Dr. Kapoor to share his experience with us relating to his work in this field and the challenges that are involved in such cases. Before we begin, I would like to underline the importance of dialogue in this session and invite enthusiastic participation from all present. Thank you once again, and looking forward to an interactive session and an enlightening one. I now request Dr. Kapoor to take it forward.
Yeah, thank you, Gandha, and welcome all those who have joined this session. To begin with, I should like to express my gratitude on behalf of the Association of Medical Consultants to the Center of Mediation and Conciliation, who are doing fantastic work and have really initiated us into this very, very important field, and the Bombay Chamber of Commerce, who has taken this very, very great exercise, helped us to understand the various nuances and to take it forward so that really practically it could get functional, which is a great need. Now, essentially, we are going to be talking about mediation and dispute resolution in medical legal cases. Now, these, as I said earlier, is a little bit different from the usual type of disputes. As we all know, the latest buzzword in legal circles all over the world and even in India is alternate dispute resolution. A statement from an American legal expert sums it up, that the courts of this country should not be the places where resolution of disputes begins. They should be places where the disputes end after alternative methods of resolving disputes. USA, let us see what is the position in USA. How many malpractice lawsuits go to courts go to trial in the USA? The vast majority, just mute my phone. Just muting my phone, please, just a moment, because might get some calls and all that. Yeah, okay. So the vast majority of cases in USA, medical malpractice cases, they are resolved outside the court. Few of these types of lawsuits go to trial. Almost 90% cases are resolved by the alternate dispute redressal mechanism. An average out-of-court settlement
Dr.
is,
Kapoor,
yes, sorry,
this-
you can't hear me. Hello? Hello?
We can hear you, yes, sir. We can hear you.
You can hear me? Is there anything?
Yes, yes.
No,
We
Ganda
can
was
hear
saying
you.
something. Ganda wanted to say something.
No, sir, I think Ganda has some connectivity issues because the video is frozen. So you please continue.
Okay, okay, all right. Now, an average out-of-court settlement is $425,000 in the USA, whereas the average court award is $1 million. Hence, it is a lot cheaper. Now, the same thing is likely to happen in India, where we are now seeing very high awards in crores. You know, the highest awards were 13 crores in a Kolkata case. So same thing is going to happen, and all the more reason why ADR, particularly in medical legal cases, would become extremely valid and desirable. Now, the reason why insurance companies are averse to it and would rather have a court decide the compensation. Now, let me explain. In India, most doctors protect themselves by what is called the professional indemnity insurance, which would protect them by against litigation costs, against awards if they are given. But in India, unlike the USA, the Indian insurance companies are averse to settling cases out of court. And the reason is, A, they know that the cases drag on for years and years together. And so they'd rather let the case run its course and then pay the compensation. And secondly, the reason is that what I understood from the insurance agencies, that they have this audit and vigilance and so on, where they are questioned if they settle out of court. They're asked, the auditor would ask, why did you settle out of court? We might have won the case. And so they are reluctant to sanction out of court settlement. Now, this is one issue which at the AMC we have tried to resolve to some extent. Now, essentially, we have some criteria. Not all cases of medical negligence we recommend should go for the ADR or for mediation. It's only a selective cases, and we have divided these cases according to the type of negligence that is alleged. Now, I have divided the type of negligence into 4 types. One is the real negligence, that is negligence which is very apparent, which it would even come under res ipsa locator, where the facts speak for themselves, and which we say that the case is indefensible. It is not defensible. Suppose somebody has operated on the wrong side of the body, somebody has left a foreign body or a mop in the surgery, or some blatant negligence. That kind of thing, we call it indefensible, and that we always advise should be settled out of court and should be settled in an amicable manner. Then there could be damage following occurrence of known complications of a procedure. And provided, the courts have stressed that provided informed consent has been taken, that the patient has been informed of the various complications and risks involved in the surgery and has consented for the same, then of course we would think that this is not a right case for ADR. And thirdly, there is what we call perceived negligence, where patient being a layman imagines or truly believes that there was negligence, and that of course we advise that it should be properly explained with good communication skills. It should be the misconceptions of the relatives or the patient should be sorted out. And lastly, I have classified into non-existent or mischievous or motivated or fabricated or also called vexatious complaints or allegations against doctors. And these, in no event, we would like to even speak about alternate dispute redressal or even any mediation whatsoever. So there are several cases which are genuine cases of negligence, which the contemporaries also feel, the doctor himself feels that he was negligent, and apparently that this should be settled amicably. Now the other problem is that sorry, one moment. Yeah, so as I said, the indefensible cases, we have no issues. But as far as insurance company is concerned, because the insurance cover would protect, that is the reason, very reason why insurance cover is taken, the professional indemnity, which indemnifies the doctor. Now, we explained to the insurance company, at least the insurance company with which we are insured, we have a group insurance, we explained to them that such cases, if they are settled amicably and through alternate dispute resolution, these are win-win situations for all concerned. They're win-win for the patient, because he doesn't have to go through a lengthy trial. Same thing for the doctor. He doesn't have to go through a lengthy trial. The hospital, which may be a party due to vicarious liability or direct liability, and the insurance company itself, it is win-win for them, because the courts might award much higher compensation, whereas through mediation, they would in fact end up paying less money than they would have to through the court. And also it's a win-win for the judicial system, which is overburdened with cases, and so that many cases go out of the system. And this is what our insurance company, we could convince them, and as of now, there are several cases which we have successfully mediated. I won't say mediated, because technically we are not really like Ganda is a mediator. We don't have that way formal training. But what we have done is that most of them, we have been able to, such cases, settle amicably through third parties, through the opposite advocate and things like that. But now there's one more issue here, and that issue is, which last time in our workshop also I had mentioned, and many had said that there would be a way out for that. The insurance, what we do is, when a patient receives, when a doctor receives a legal notice from a patient, the legal notice says that these are the allegations, and within 15 days, within 20 days, if you don't pay 50 lakh rupees, we will file criminal case, we will go to consumer court, we'll go to the medical council, and so on. Now, we try to settle, we try to negotiate with the patient at that stage in an appropriate case. But as far as the insurance company is concerned, they are not quite happy. They say this is because the clause in our insurance policy says that out-of-court settlement is permitted. But they said this is not out of court, this is pre-litigation. So they differentiate between pre-litigation and out-of-court. They say out-of-court means first the case must go to court, and then only you tell the court we want to settle, and you settle, the consent terms are filed in the court, and then they are comfortable with that, because they say otherwise we would not like to settle, make a payment. Now that we have, in spite of all this, we have done several cases which they call it pre-litigation, which means the case never even went to court, and yet we negotiated and we arrived at a mutually agreeable figure, and this was paid by the insurance company, which they have been doing. But we would be happy to know how this could be, this agreement, because this is only an MOU which we signed. And the fear of the many people is that this may not be very valid in law, in the sense it's an MOU, and patient might go back on his word, which happened in one of our cases where the patient, after receiving money, said that this was signed under duress, and he tried to show some evidence that they forced me to sign this agreement. He went to High Court, but his case was thrown out. So by and large, we have been doing what we call pre-litigation. The case has not gone to court. Now, another problem has come up is the new Consumer Protection Act 2019. What they have done, surprisingly, and I do not know on what is the reason for doing that, they have excluded mediation. If you go under the rules of mediation, they have excluded mediation for medical cases, especially those cases where there was a death of the patient or there is a grievous hurt. They say these cases, they would not, they are prohibiting or not accepting mediation and say the matter must go to the court. Now, this is something we are also working on, trying to go to the Consumer Affairs Ministry and tell them that this is, in fact, this is anti-consumer, because if there is any area where ADR is required, it is the medical legal cases, because the patient is suffering, and he will go on suffering for years and years till the settlement comes. And this is in fact, really indicated for medical legal cases, which they have technically, as per the rules, they have said that no, these cases are outside the purview of mediation. So this I had discussed last time also, and I was told that there is some way under the Legal Services Act or some act where it can be made, get the endorsement of the court, even though it has not gone to the court. That I will leave Ganda to tell us how this could be achieved. So I think we have covered a lot of ground so far. We have been able to settle without any formal mediation kind of thing, just by the middle people like the advocates or some people who are have good relations with the patient and the doctor, somebody who could talk, which is like an informal mediation. So I think this initiative is fantastic, and we'd be delighted to be part of it and to contribute our experience as far as this is concerned in medical legal cases, because this is a little bit situation sometimes is that patient suffers the damage, and he is now undergoing a lot of expenditure, and he expects the settlement that time. He needs the money at that time, and so this can't be done in a hurry, and that is where sometimes the things fail, and ultimately patient goes to the court, and of course neither the patient benefits nor the doctor benefits. So I think these are a few of the areas which we need to really touch upon, and to find some measures where this could become, there could be a protocol and we could regularize it, and possibly our association also considering to set up a grievance redressal mechanism where even before the patient goes to court, he could come and there could be some kind of understanding of the problem. So I think this is what I'd like to convey, the special issues in medical legal mediation. And over to you, Ganda. I think you might be able to help out with some of the problems we are facing. Thank you.
Thank you, Dr. Kapoor. I've noted all your questions, and I'm going to try and address them as many as possible within the time. But before we actually address those specific questions, Dr. Kapoor has over and over again mentioned ADR, alternate dispute resolution. And I'd like to give you an introduction to ADR, understand the concept, and then specifically try and understand how that we can apply that concept to medical legal cases or cases more broader to the healthcare industry. So if we see, these are the typical kind of cases or disputes that arise within the healthcare industry. We have internal conflicts. It's an organization. People work together and conflicts are there, they're present. And we do see a lot of conflicts, internal conflicts between clinicians and management, intra-department issues, issues between doctors and nurses. And sometimes these do flare up and affect the functioning of the organization, or we lose valuable resources. There are also cases of discrimination, harassment, and disciplinary issues. We have business disputes within the healthcare industry of vendors, contractors, service providers, and suppliers. And we do have issues that doctors spoke about, doctor-patient conflicts, which is the major chunk of the conflicts that arise in the healthcare sector. These relate to billings and payment, acts of omission and commission, and medical negligence. So these are all the cases, and ADR can be used in most of these cases, if not all. And let's first understand what that is. First of all, our traditional methods of resolving these issues have been to file cases, either a civil, criminal, or go to the consumer forum, or look at constitutional remedies where we feel that fundamental rights have been violated, or we have, an order has been passed which does not, is blatantly wrong against us. So there are certain remedies that we have used. Dr. Kapoor has highlighted how, they have, despite these remedies being available, in some cases, they have still preferred to use mediation or negotiation and try to resolve disputes. But when it comes to external stakeholders, I mean, basically patients and others, they prefer to go for these methods. And as we know, they're time consuming, but more importantly, they tend to be more public in their nature. They tend to attack on the reputation of the hospital and the doctors, and actually are very expensive in the long run because of the kind of time commitment and resources that you need to invest in managing them. So what are the options? We have alternate methods, which include negotiation, mediation, conciliation, and arbitration. They are called, these collectively are called ADR methods. And when we resolve dispute online, we also have a new term post 2020, which is very much in use, and all of us are using it now. It's called online dispute resolution, where we actually conduct all these processes online. So just to understand, there's a stages through which a conflict or a dispute goes. First of all, we need to be aware how to prevent it. So in the medical field, the importance of consent, proper documentation, process-centric approach, basically doing your duty, the duty to care, are ways in which you can prevent conflict from arising. Communication is another point. It's very important that if these things are taken care of, there are fewer chances of conflict arising. But in the event conflict does arise, we use the tool of negotiation. Now, Dr. Kapoor has mentioned over and over again how doctors have over a period of time negotiated with the patients to find a solution outside of court. And that's negotiation. So basically, where parties themselves negotiate, either with the help of lawyers or without, that's negotiation, where the two involved parties are in having a dialogue with each other. But there is another method where it's non-adversarial ADR where mediation and conciliation can be used. And here what happens, you have a neutral facilitator who helps parties negotiate with each other. Now, the difference between the two, the primary difference here is a negotiation. In a negotiation, you come up with a contract which is enforceable under the Contract Act. So it's like an agreement between the parties, but it's got no legal binding as such in terms of in the courts. And that's where the question of the insurance companies accepting that agreement comes in, because there's always a chance that one of the parties may breach or challenge that. Because it's only the parties, there is no third party or there is no legal sanctity to that process. Whereas if you go through a process like conciliation, it is an act which provides for this process. You have a facilitator who helps you come to an agreement. The agreement is drafted in a way that it becomes enforceable, or rather there is sanctity under the law for that agreement. And therefore there is certain amount of sanctity or recognition for that agreement. And that is the difference between these two methods. Of course, the fact that a facilitator would be able to diffuse the tension between the parties and handle the conflict in a much more streamlined and process-oriented manner. But apart from that, the fact that the end result, in the sense that if the parties do come to a settlement, then that agreement, either the mediated settlement or the conciliation agreement, that has more validity in the law than a contract that's entered into between the parties as a negotiated agreement. A small rider here, the mediation bill is still not, it's still a bill, it's not enacted. So the word mediation, when you use it, it still is a negotiated agreement. Whereas when you go under the Arbitration and Conciliation Act, that's the time the settlement agreement gets the sanctity of the law. So that's why we use these terms. The process as such may remain the same, but currently the word conciliation is backed by an act, the Arbitration and Conciliation Act 1996, whereas the mediation, the provision of mediation is still pending. The bill is still pending in the Parliament. So that's where we stand as far as the law is concerned. After that, we have arbitration. Now, arbitration is an adversarial process. What does that mean? In a non-adversarial process, the parties collaborate and try to find a solution. So they basically separate the solution from the problem from the people, and they both together try to find a solution. That's the job of the facilitator, to try and find a solution to the problem. Whereas in adversarial ADR or an adversarial method, both parties just put out their points, and a neutral third party decides what is right and wrong. So in that sense, it is very similar to the litigation process. However, it is a more private process. All the challenges that we face in court in terms of the time following the process, the civil procedure code, and all of that is we don't have to. So it's a faster process in that sense. And of course, it's voluntary in terms of the parties choose the neutral person, and the litigation is what I spoke about as traditional methods. That's another step. If we go for arbitration, there is it's basically a substitute for litigation. You don't have to go, I mean, you cannot do litigation and arbitration simultaneously. It's either arbitration or litigation. If you see the stages of this conflict resolution process, the hostility, cost, and time to achieve the resolution increases. It's the least if you prevent the conflict. It is less if you negotiate and come to a settlement. It is relatively higher but lesser than an adversarial method if you use a non-adversarial method. And it escalates as you go for private adversarial method, and it escalates further if you go for litigation. So those are the steps in a dispute resolution process, or rather the various methods available and what happens in those. What would you say is the primary difference between these methods? Of course, the fact that there are adversarial forms of dispute resolution and non-adversarial. But the main thing is that in negotiation and mediation conciliations, the parties control the process. What I mean by that is that the parties enter the process voluntarily and can exit the process at any time voluntarily. It's non-binding till you reach a settlement and you sign a settlement. So just because you have entered into the mediation process does not mean that you have to walk out of it after signing the agreement. It is only if you reach a settlement that you that you actually believe in and it works for you. That's the time you sign the agreement. If not, then you may walk out of it and you may prefer to use another form of dispute resolution. So for example, like when Dr. Kapoor said that sometimes the demands are very high, or there's extortion, or there is, he used the words, he used some strong words to explain what happens when there are very high demands. And in those cases, it's fine for the party to walk out, for the doctors or the hospital to walk out of the mediation process and say, okay, we'll handle it in arbitration or we'll handle it in litigation because we cannot mediate a case like this. So that's the part about parties controlling, how, having control over the entire process, not just the process, also the outcome. And in arbitration, what happens is the parties have to agree to arbitration earlier. Once they subject themselves to arbitration, there are very few grounds on which you can challenge that arbitration. You need to subject yourself to it and it continues. So the control of the parties is not there. However, there are many cases which are more suitable for arbitration rather than mediation, particularly cases where there is an alleged medical negligence, but actually there is none. So in those cases, it is better that, in many cases, it's better that, the evidence is looked at and a finding is made to that effect. So that is about the three methods of dispute resolution and how parties can control the process. Once again, what's the difference between arbitration and conciliation? As I mentioned, one is adversarial in nature, the other is non-adversarial. In arbitration, the arbitrator or the neutral decides the outcome. In conciliation, the parties decide the outcome. Both the methods are private and confidential, unlike litigation where everything happens in the open court. Arbitration and conciliation are conducted in closed doors between the parties only, and there is privacy that is maintained. Arbitration is a more formal process, and conciliation is conducted in a more informal manner. Arbitration is legally binding once you enter into an arbitration agreement, and the award is also legally binding. Conciliation and mediation is a process that's not legally binding unless you have signed a settlement agreement after going through the process. So that's the primary differences between the two processes. In mediation, the parties decide the final outcome, That's the most important. So if you're looking for a solution that you want to curate, then mediation is is the method for you. If you want somebody else to decide basis the evidence, then arbitration is the process for you. That is about ADR. What comes next is institutional ADR. What CMC offers is institutional ADR. CMC is a body which conducts or provides ADR services. What we have is administrative support, right from accepting the case, studying the case, to giving you options of a panel of neutrals to select from, and all our neutrals are trained, and there is a criteria to empanel them. And only if you go through that criteria, you get empaneled. So they are generally experienced and trained neutrals, and you can choose your neutrals. The parties can choose their neutrals. The approach that institutional ADR gives. So ADR can be, if you can approach any mediator or arbitrator as an individual and ask them to arbitrate your case or mediate your case. Or you can approach an institution and you get options of a panel of mediators and arbitrators and neutrals that you can choose from. And the advantages of going to an institutional ADR firm or a place like CMC is, the approach is professional. They have structured procedure and processes defined, that when you approach them, what are the steps that they will be taking. There is administrative and documentation support. So all your records are maintained and they are destroyed when your case is over. So confidentiality, privacy, all of that is also maintained. It's a safer way of conducting a case rather than, entrusting individuals, particularly if you do not know much about individuals, neutrals. The guarantee of neutrality, because as a body, they're not really concerned about individuals or clients. They are more concerned about providing services in a way that they are recognized as a credible institutional ADR provider. And a panel of trained professional neutrals to choose from. So this is what we are offering as CMC, an institute that offers ADR services and a panel of experts along with administrative services to manage the cases that come to us. You would wonder that why will people you deal with want to come to CMC or any other institutional ADR provider to resolve their case. It's fine for somebody who's attending this webinar has understood and they want to come, but what about the other party? How do you convince them? So now that ADR is becoming a buzzword, it's quite common for people to know about institutional ADR, and we do come with a certain level of reputation, and to ensure that people accept it. It is better to have ADR clause in your agreements before a dispute arises. So in all documentations that you maintain with your stakeholders, it is better to have an ADR clause and ensure that that's a mechanism that's already built into your in your business. This includes documentations you maintain with patients as well as documentations you maintain with other stakeholders. So if and when a case does arise, that's the first option. Of course, they can say no and they can use other modes of dispute resolution. But generally, if there is a neutral body in the picture, nobody really wants to get into litigation and spend that kind of money and, and actually go through that hassle if they know a neutral, a really reliable service is available as an alternative. We have shared along with the emails that have gone to you, and we can share it again. The model ADR clause for the ADR services offered by CMC and the Bombay Chamber of Commerce, because currently CMC is offering mediation services and the Bombay Chamber of Commerce has a panel of arbitrators with their own rules that's offering arbitration services. So we are offering everything under the same organization, just that the clauses and the rules have to be different. So the exact clause has been shared with you. Now we are talking about neutrals, and what we need to understand is, if you as a person who has a conflict is approaching a neutral, what is it that you're looking for in the neutral? First of all, professional expertise. He can be a lawyer or a domain specialist. So if, for example, right now it's very popular that we have a lot of engineers who are mediators, because disputes relating to technical disputes relating to the engineering industry, or also architects, disputes relating to the construction industry. A lot of these professionals are getting in, are enrolling themselves as neutrals, getting trained, because there is a need for specialists in the industry to actually be able to help people with their dispute resolution. You will understand that people from your industry will view a conflict very differently from how a lay person who's not part of your industry will view it. The understanding that a doctor has of how a medical case is handled, the challenges that are there for a doctor, and somebody who basically looks at it from as an outsider who's not part of the system, the approach is completely different. The understanding is completely different. It's very easy to blame the professional if you don't know the circumstances in which they are working, which is why there is a demand for domain specialists to be appointed as neutrals. We also have something called co-mediation and arbitration panels, where we have a domain specialist and we have lawyers who work together to find solutions or resolve the conflict. So one of the things that we look for is professional expertise, communication skills, independence and impartiality. So if you are looking for a neutral, you cannot pick up an employee from your own organization and appoint him as a neutral in a case involving your organization. It's very important that the person you're appointing is somebody who best is not known to you, or even if he is known to you, he has no interest in your business or is not related to you. What we call this is a conflict of interest. He has to have no interest in the subject matter or the persons involved in the conflict. So if there is a conflict of interest, the person is no longer a neutral and should not be appointed. And therefore, having a panel and being able to choose where you have various people to choose from on the basis of their professional expertise and other criteria, it's a very important resource to have. The reputation of the individual. You don't want a person who has been found guilty or has been involved in cases of fraud or malpractice to be appointed as a mediator, because there always will be a doubt in the minds of the parties. What if this person is not being fair to me? He has this reputation. So having a clean reputation and being trustworthy is another quality that you look for in a neutral. And most importantly, the neutral needs to be trained and understand the process and be able to provide you have the skills that he has learned through the training to be able to actually facilitate a resolution or actually be able to decide on the basis of the evidence before him. So those are primarily the qualities that you're looking for a neutral when you are looking for somebody to help you resolve a conflict. And at CMC, that's what we are offering. We're offering a training for you not just to understand the ADR process, but also to be trained as a neutral, to be able to facilitate mediation as a facilitator, as a neutral. And so this training will be conducted online from 5th to 25th of June. The sessions on 24th and 25th June will be conducted in hybrid mode with an option to attend the same in person in Mumbai. And participants will be considered to be enrolled as CMC mediators on our medical legal panel after the successful completion of the training. Now, this is subject to we have a process that is defined for empanelment. The training is mandatory, but there are other criteria which includes supervised, observation and interviews and things like that, which we will explain to the candidates who would like to enroll as on the panel. So this is what we're offering. And what are the objectives of the mediation training? The training will be interactive. It's not lecture series, it's a training. So it's a workshop format where there'll be a lot of interactive sessions and industry-specific simulations. What we are aiming at is to learn effective communication skills in emotionally charged situations, art of negotiation and facilitation. We are going to have a session on the law related to medical legal cases, a more detailed understanding of the law related to an ADR, because we have offered you different methods of ADR. But what's important is, as somebody who's trained in it has to understand what method to choose. There's no one method better than the other, but to be able to understand whether in this case I need to go for arbitration, I need to go for litigation, I need to file a criminal complaint, or I have to mediate or negotiate, is a decision that one needs to take. And having an understanding of all the methods that are available to you, what are their advantages, in what cases do they provide better results, is very important to take that decision. So that criteria and understanding we will get through these sessions. And very important also, formulating agreements that are enforceable and binding after the mediation process. So these are the primary areas that we will focus on. Of course, the process and communication, negotiation, and facilitation are the three primary modules, and these are the objectives that we are going to cover from out of that. So that is about the training that we are offering, and a little bit about ADR. We are happy to take questions. We have a little time, so please ask any questions that you may have about the course or about what I just spoke about or what Dr. Kapoor spoke about.
Hello, can you hear me, Ganda?
Yes, yes.
Hi. So I had a comment, or rather, what you said appealed to me a lot. That a domain expert is very important in the process, because as in medical legal case, only the domain expert could really understand the difficulties or the practical aspects of it, which a non or rather a lay person would see. After all, the patient also is a lay person, and his complaints also are based on lay perceptions. Similarly, the mediator also is a lay person as far as the dispute is concerned. So that part, it has to go hand in hand. So that you rightly said that it's the domain expert would also be part of the team which is doing the mediation. That would become extremely important. And in fact, there, what you mentioned about the panel, that also appeals to me, because we have various specialties. And for example, there is a patient who underwent an orthopedic surgery, for example, and he suffered a damage, and now he is making claims of negligence and for compensation and so on. And if he comes, then really a cardiologist will not have that domain expertise. So you need a person of that particular branch. Now that is why when we even in criminal cases, as per the Jacob Matthew judgment of Supreme Court, it has said that a doctor cannot be arrested just on a mere complaint by a patient. That entire facts of the case have to be sent to an expert committee, preferably of a government body. Like in Mumbai, it is the JJ Hospital, government JJ Hospital, where all the file is sent to the JJ Hospital, which appoints an expert committee. And even in the Jacob Matthew judgment, very, very rightly it has said that at least one of the people on the panel should be from the same branch of the accused doctor. So that's also important. A cardiologist cannot opine on the rightness or wrongness of the treatment given by a orthopedic surgeon, and vice versa. Suppose there is an orthopedic surgeon, so that domain expert also would be domain of that particular complaint, So that would become important. And that's why what you said appealed to me, that there would be a panel. And suppose it's a medical case, obviously you'd like to have a medical domain expert. If there is a gynecological case, then there should be a gynecologist. So these should be all, as you said, maybe trained people, little bit with this ADR mechanism, etc. But they bring with them the value of their domain, of that particular branch. So that there could be many domains. That's what I'm trying to say. So I think that is a good point, and which is what can be amplified in this manner.
Yes. Absolutely, Dr. Kapoor, and that means we need more and more people who take interest in this subject and
right,
and get trained and help us resolve this conflict.
Absolutely. There will be great partnership, because and of course here what it would be a two-step process. First, the domain they could filter the cases. As I said, there are certain cases which are not worth mediating, which either they are the words which you could not recall, they are vexatious or mischievous or kind of things.
Yes.
Those type of cases, we would not want to do a mediation in that. We don't want to encourage litigation and send a wrong message that anybody can get up and put up any complaint and it will be entertained. only selected case. It will have to be filtered. So first it will be filtered and then come to you, along with the domain expert.
Yes, Dr. Kapoor.
So I think that's the process which we would have to follow.
Thank you so much. Absolutely agree with all or everything you have said. And actually, to make those decisions, we do need to be aware of the processes that are available to us. I'm going to invite Mr. Jawad. He's part of the CMC mediators panel and a senior mediator. And to add something, and Mr. Jawad, if you could also address the questions which are related, which are, asked by Dr. Nikhil Datar, and basically in the same line of ADR, mediation, conciliation, and enforceability, and whether mediation and conciliation, the Arbitration and Conciliation Act applies to medical legal cases.
Thank you, Ganda. First of all, congratulations to you and Dr. Kapoor for a very lucid and very clear presentation on all the issues that come out of medical legal cases and how they can be resolved in a peaceful manner by resorting to ADR mechanisms. I just wanted to comment on what Dr. Lalit Kapoor pointed out, because sometimes when there is a direct negotiation between the parties, it is only a contract that you reach if you settle the matter. Now the question is, how do you enforce it? Because if it is a contract, they have to, one of the parties defaults in performing his or her obligations under that contract. The only option is to go to court and perhaps file a civil suit or something, or maybe include another arbitration clause, mediation clause in that contract also. Now the way out of that is, as of now, we don't have the mediation law which has been passed. But it is likely to be passed very soon, hopefully. And that confers the status of an arbitral award on a mediated settlement agreement. So what happens is you don't have to go and file a suit or initiate other legal proceedings in the sense that, de novo, absolutely new proceedings to enforce that. You can straight away go for the execution act, as if you are already holding the decree of a court or already you're holding an arbitral award. So that facility is there for you if you opt for mediation. And already the Arbitration and Conciliation Act, I would just like to invite your attention to section 74 of the Arbitration and Conciliation Act. Part 3 of the Arbitration Conciliation Act deals with conciliation. And the section 74 also confers the status of an arbitral award on agreed terms upon an agreement that is reached through the process of conciliation, which means that the agreement that is reached through conciliation can be directly executed in a court of law if any of the parties default in fulfilling their obligations. You can also use that as a defense. If one of the parties reneges on that or resiles from it, that is always a defense for you, saying that there is a conciliation award in our favor. So hopefully when the mediation law comes, that same logic will be applicable. Now, one of the points that you also made, Ganta, is that having an ADR clause in whatever contracts that are entered. Because, for example, you have a consent form that you get the patients to sign. I think one of the useful things would be for hospitals and medical professionals to include a clause there which says that parties will undertake a good faith negotiation if that fails. But negotiation again has its pitfall, because even if you reach an agreement, it may not be enforceable or executable like a decree of the court. So it's better to have a clause which says that you will go in for conciliation first, and if conciliation fails, you will go in for arbitration. So we have what are called as, usually I'm using the word conciliation now because there is a law on conciliation. There is no law of mediation. So I'm using the word conciliation, but universally we have these med-arb clauses where mediation and arbitration, if supposing mediation fails, you go for arbitration, or you go for arbitration, and if the arbitrator will refer the parties to mediation or conciliation, and if they are able to resolve their disputes in the mediation or conciliation, the arbitrator passes an award. So there are different permutations and combinations. So you have med-arb, you have arb-med, you have med arb med, okay, and you have arb med arb. So these are all the different options that are available. So what is very important now for, I think, the medical profession to consider is to add these clauses. So you pointed out to three kinds of disputes. One is internal disputes. The other are disputes with where hospitals enter into contracts with vendors, etc. And the third one is the doctor-patient conflict that might arise. So that is one thing. That is the second thing that I pointed out. Now, one more thing that you said, that all records are destroyed. Now, I just want to clarify there that when it comes to destruction of records, it's mostly about what actually happens in the mediation or the conciliation process. Now, if it's an arbitration, there is no destruction of records. But in mediation and conciliation, because it is a confidential process, supposing the mediation or conciliation fails, it is covered by confidentiality. So supposing any proposals are exchanged, any offers are made, that remains confidential. So nobody can go to the court and say that this offer was made to me in an in the mediation or conciliation, or such an admission made by so-and-so in the mediation or conciliation, or please call the mediator or conciliator as a witness. So that confidentiality is attached to the entire mediation or conciliation proceedings. So that is one thing. The third thing. One thing that I would like to urge everybody to consider, because most businesses or service providers in India, we don't focus on dispute resolution at all. We don't anticipate disputes. We don't cover for those disputes. We don't take necessary steps. So it's very important that CMC is conducting this program, and I hope that people understand the importance of this. Now, to Dr. Nikhil Datar's question about the enforceability of a clause on mediation, conciliation, or arbitration. Now, if there is an arbitration clause, that is why I think it's very important that when you include an ADR clause, it should cover both mediation and conciliation and arbitration also. Because when there is an arbitration clause in the contract, now what happens is nobody can go to the court. So supposing, let's say that there is a doctor-patient dispute, and the patient goes to the court. Now, you can always go there and tell the court that, look, there is an arbitration clause, so please refer it to arbitration. So once you bring it to arbitration, there you can take recourse to mediation, conciliation. If that fails, you can go for arbitration. The other question that Dr. Nikhil Datar asked is about, I think, special perspective in the medico legal field. Yes, that is definitely going to happen. I'm just trying to see if there are any questions.
There is one more question. It is, how is ADR this ADR is different from police ADR?
No, I don't know what they mean by police ADR.
Mr. Shashank Joshi.
No, that is accidental death report. That ADR is accidental death report. That's quite different. Nothing to do.
Okay, yeah.
ADR is accidental death report.
Okay.
Yes. You answered the question yourself.
No, I did not ask the question.
Okay.
No. This is Dr. Kapoor. I'm Dr. Kapoor speaking.
Oh, okay.
No.
So alternate ADR in this context,
Okay.
not in the context in which Dr. Lalit Kapoor and Ganda spoke, is alternate dispute resolution.
There's one more question. Yeah. Even after ADR settlement, can the complainant still go down the legal route? So I think that's already answered by you.
Yeah.
Yeah, there's one thing. Hello, can you hear me?
Yes.
Can you hear me? Hello?
Yes, Dr. Kapoor.
There's one thing, repeatedly we have been saying that there is the law on arbitration and conciliation, but no law on mediation. Am I right?
Yeah, that is right, Dr. Lalit.
That is right. Now, what has happened is that, as a matter of fact, in the Consumer Protection Act 2019, if you read there is a special clause in the rules on mediation. Now, this is a legal document. This is an act, Consumer Protection Act. With every consumer court or consumer forum in the country, there is attached a mediation cell as per the act. And necessarily, if somebody makes a complaint to the consumer court, the forum, the bench, is supposed to first refer the matter to the mediation cell. And then if it fails, then only they would entertain. This is what the act says, if you go through the act.
Yeah.
So
that is right.
yeah. So therefore, this is now well into the legal system, is it not? Though we are saying
you're
there is no
absolutely
law.
right. No, you're absolutely right, Dr. Kapoor. Now, this is what we are talking about is once a case is already filed before the consumer court. Now, we are trying to also see whether it can be done even before parties go to the court. Because see, what happens, a lot is at stake here. If supposing the hospital is unnecessarily dragged to the court, the news somehow comes out and, it becomes a huge publicity disaster after that for the hospital, for the doctor. So reputations are at stake. So this is where pre-litigation, before even parties go, because you are absolutely right when you say the Consumer Protection Act itself makes mediation mandatory. That is only after the parties have gone to the court. Now, what we are also trying to say is that you don't necessarily have to allow it to go to court. If you have an ADR clause, you can perhaps preempt that and say that, okay, let's go for this, so that there is confidentiality, there is protection of the reputation before things get out of hand. So that is something that, unless of course the law.
See, that is exactly. We have already. This is exactly what we have been doing. As I mentioned, what we have been doing is pre-litigation. As you said, that is, of course, we would prefer that any day for a pre-litigation. However, our problem is with the insurance company, as I mentioned to you. When they indemnify you, they are not giving too much importance to this pre-litigation document, unless, of course, as now that the mediation, mediation mechanism which you are proposing, if it goes through that, then it becomes legal. So that is good for us. Then that is pre-litigation, and yet it has the stamp of some legality which would be accepted easily by the insurance company. So I think that for us, that is the way forward.
Ganda, you also have a question from
Yes.
Dr. Nikhil.
From Dr. Nikhil, he wants to speak. So, Dr. Nikhil, may I invite you?
Well, let me introduce myself. I am Professor Dr. Nikhil Datar. I am Professor of Health Law at the Maharashtra National Law University. The question is very legal, and that's why I thought of unmuting myself. I need to understand basically the difference between the conciliation and mediation, because we have the Arbitration and Conciliation Act, which is already passed, so that's not a real problem. Mediation becomes very informal. And since there is no act, I mean, as long as the act is not passed, using word mediation being very informal, okay, may not be a binding. But if at all we are able to say that we need to go, I mean, the question which I kind of, is a follow-up question in a way, that I said that if our consent forms primarily say that, the next step for dispute redressal will be through under Arbitration and Conciliation Act, then since it is under an act, it becomes a more formalized mechanism, and according to me, it will be a more bigger binding on the parties to accept that particular part rather than using the word mediation. That's what is my understanding, but you can clarify more.
You are correct as of now, till we have the Mediation Act in force.
Yes. Ganda,
Yes.
can I just clarify that?
Yes.
See, what we do here in Delhi is even when a matter is referred for mediation, Section 64 of the Arbitration and Conciliation Act says that you can appoint the same person as a conciliator. And once that happens, under Section 74, instead of a mediated settlement, what is now is a conciliated settlement comes into being, and that is a deemed award on consent terms. And therefore, that becomes enforceable. So even if there is a mediation clause, we can still use Arbitration and Conciliation Act by appointing the mediator as a conciliator.
So what's really a legal difference between conciliation and mediation?
Well, the little difference is that a conciliator is a little more proactive as was said, he's a domain expert. Like mediator basically is a person who specializes in the process.
Okay.
And what Dr. Kapoor said, that issue can also be taken care of. You can have a mediator plus a domain expert as a co-mediator.
Yes.
And therefore both can conciliate. So one is a process expert, the other is a domain expert.
Correct. Correct.
And so that is how we have been, dealing with such situations. Ganda, I just only want to add one more point to what Jawad said.
Yes,
See,
please.
the advantage, what Dr. Kapoor said, is the atmosphere is very hostile when the matter goes into litigation. Anyway, there's a lot of angst. The parties are hurt, and therefore the communication completely breaks down, and the atmosphere becomes very hostile. What mediation conciliation does is it gives a chance for the parties to vent, so that the emotional content of their dispute is taken care of, and then rationalization sets in. I'll tell you a case where a nursing home was sued by this person who lost his father. He sued them for negligence, for lack of care. He was demanding a lot of money, and ultimately, do you know what the matter was settled? How the matter was settled? By an apology. And the money that was coming in, he did not want it for himself. He said the nursing home should upgrade itself so that this kind of incident does not happen in future. All these issues can only come out in mediation. They will never come out in court, in litigation. So that's the advantage of mediation and conciliation.
Sir, as a follow-up question, I wanted to ask you, see the rules, as Dr. Kapoor mentioned, the rules of the amended Consumer Protection Act categorically say that mediation cannot be used, okay, for the disputes which are related to death of a person or grievous hurt. Now, practically speaking, we have seen that most of the matters, when they go to the court, they definitely fulfill the criteria of it being a grievous hurt. Now, when Consumer Protection Act has categorically said that you cannot mediate it, and on the other hand, when my consent form, which is a contract between doctor and patient, categorically specifically mentions that the first step should be Arbitration and Conciliation Act, okay, as the first dispute redressal mechanism. In this kind of a situation, how should one look at it from the legal perspective? I mean, would presence of a specific contract which is in between two persons hold beyond and above a General Consumer Protection Act, or would the Act hold above a specific contract between the two parties, and any case law in relation to that?
Look, let me attempt it in this manner. Any person who moves, who wants to go to the consumer forum, has to be a person who's affected, the stakeholder, a person who's actually been wronged. So in case if there is a mediator or a conciliated settlement, who will move the court? No one.
Okay.
So once the matter is settled between the two, see, you cannot stop a person from going to court. But in case if there is a mediated settlement, 99% chances are parties will abide by it.
Okay.
Because this is their own curated settlement. They have themselves arrived at the settlement, so they will honor it. And we have never had an issue where 99% cases where parties have resolved that they have gone to the court again. So ultimately, somebody has to move the consumer court. Well, question is, this aspect is still to be answered, whether, you see, if there is an arbitrator or a conciliated settlement, which we told you has a force of a decree, tomorrow, can a person be stopped from going to the consumer court? That's a question. Where what will prevail? I don't think that there's still a judgment on this.
Because this question becomes very crucial and important for us, not only from the ADR point of view, and Dr. Kapoor will agree with this, because we have had a discussion earlier on that the new Consumer Protection Act has got in another very crucial provision, and it says that the person, I mean, up till now, the standard practice was that one can move the court in the jurisdiction where the hospital is placed. Now, under the new Consumer Protection Act, the party can move the court, of the area of his own residence. So it can very easily be used as a methodology of harassing I might get a call from the district consumer commission of some Jumri Talaya from UP or somewhere. Okay, and then that becomes a source of harassment. So basically, if at all suppose this specific contract prevails over the general terms, then even that harassment can be taken care of automatically, because I will have to say that, well, you have signed up onto my consent form, which primarily says Arbitration and Conciliation Act and the seat placed in Mumbai, because I am located in Mumbai. So that can help me to kind of get myself protected and cushioned away from the another source of harassment, which is potentially likely that we will be harassed with.
Dr. Nikhil, by a contract, you cannot override a law.
That's exactly why I said that there is. I mean, when it gets applied to mediation, we are saying that maybe probably. I mean, I agree with you what you're saying, that primarily if it's a pre-litigation, then the matter doesn't come up in the court at all. That I agree with you on that front. And that's exactly what it is, that if at all there is a pre-litigated, I mean, the pre-litigation stage, if there is an arbitration award or a conciliation award, then primarily the matter won't go only to any kind of a court. And if at all it is not going to go to the court, then I don't have any reason why should I get a summons from some Jumri Talaya consumer forum or something of that sort. So it will help me in dual manner to protect myself.
In fact, mediation creates a very safe process, safe environment, atmosphere for purposes of parties, so, to negotiate. And that's why mediation helps in removing a lot of those angst and, hostility. And after that, let's say, even if there is no settlement, parties have lost so much of, that venom has gone. Because, once there is, parties have had the opportunity to have the other person's perspective. Actually, all the walls are built because we don't know the other person's perspective. We only know our story. And mediation helps, to create that particular atmosphere where you hear the other person's perspective and you cool down. You start rationalizing. Maybe it was really not his fault. The person on the other side was not at fault. And that's where mediation, conciliation are actually necessary before parties attempt any litigation.
I think we should take a comment from Kapoor sir also on what I said and what are his views on it.
Sir, unmute yourself. We can't hear you.
Yeah, sorry. See, I'll give you my opinion. Presently, we have settled several cases through pre-litigation, in spite of not having a very legal kind of validity. And yet, we have had only one case where that did not work. And in spite of that, the patient went to the court, but he was thrown out of the court. The court said, you have signed such a big document, you understand what you have signed, and now you can't come back and say that this was under duress and all those kind of things. So I feel, in my mind, the ideal solution is our same mechanism of pre-litigation, which we have been successfully doing. With that, we involve the Center for Mediation and Conciliation, and that will make it acceptable to the insurance company. So I think our entire problem gets solved. We are doing pre-litigation, not allowing to go to court. We are doing it in a cordial manner and with the domain expert plus the professional mediator and with the sanctity of which the Center for Mediation and Conciliation of Bombay Chamber of Commerce has got. That combined with that would also satisfy the insurance company. And I would rather avoid writing anything of arbitration or conciliation in my consent form totally. I would be very unhappy to put that, because it plants ideas into the patient. Even a fellow who doesn't want to do anything or he reads that mediation, so arbitration, then immediately he starts thinking about it. The seed is sown, and I would rather not put in the consent form at all, but do this pre-litigation plus this professional mediation, which will be accepted by the court, by the insurance company, and I think all our problems get solved. Hello?
So, yeah, thank you, Dr. Kapoor.
Yeah.
So
So I
there is a
think we have a-
question here, which I'm going to address. So there's a question that if the nature of the assault of the complaint is serious, like in sexual assault by a clinician or POXO, can ADR be initiated? So my response is that
No.
POXO has to be reported. It's mandatory that POXO has to be reported by anybody, any citizen who knows about sexual assault on a child or a threat of sexual assault on a child has to be reported to the police. There is no option. So there is no question of mediating or anything in a case like that. But in a case of sexual assault, if the victim consents to mediation, if she is willing to mediate, then we can look at mediation. The reason is very simple, that many times victims do not want to go public with what has happened to them. It's like repeating the offense. It's the public analysis of that assault, and therefore many times they may prefer that it is addressed and mediated or privately. So they may agree, but consent and free consent of the victim is mandatory. So that's the answer to that question. I hope that clarifies.
See, I think the criminal complaints, we have to see, many of them are non-compoundable. So if they are non-compoundable, whether the victim likes it or no, it's a crime against the state, and there is no way you can settle it. If it is non-compoundable, only some crime, I mean, so you have to find out that section, is it compoundable or non-compoundable? You know, only
So-
if it is non-compoundable, then the question of mediation would arise.
So, doctor, what you're talking about is mediation under the Consumer Protection Act, and
No,
this
no,
comes
no.
under
Criminal, criminal law.
these are the exceptions that have been given under the mediation rules
Correct.
of Consumer Protection Act, and it's basically a grievous hurt or death by medical negligence, compoundable offenses. There are a few sections that have been given, like fraud and things like that, that you cannot mediate under the consumer forum. But just like Mr. Jawad spoke about it, that if the person who has been wronged, if that person wants to mediate and is willing to mediate, that's an option that you have, that you can do it, because that person will not go to court. So that's what it is. Now, when it comes to, and that's the reason why there are these issues, that if it goes to court, the court will not send it for mediation, because those are crimes against the state. But if the victim themselves come forward and say, no, I want to mediate this, I want justice, but I want it through this process, that's something that there's nothing that stops you from doing it.
Ganda, even non-compoundable matters can be resolved, and because the Supreme Court has said, unless it's a heinous crime against the state.
Yes.
Those are the only matters where they cannot be resolved. Otherwise, like forgery, we have 406, 498A, those are non-compoundable. But every day the matters are being quashed by the court. So it's only those heinous crimes, that's the only genre. Otherwise, non-compoundable matters are also being resolved.
Yeah, therefore, we have to see which are the matter. Now, for example, murder, you can't have a murder, even if the victim says, the family says, no, we don't mind settling, the state is going to pursue the prosecution, is it not?
I agree with you. That can't be.
Yeah.
Because that's a heinous
Yeah.
crime. That's against the state.
Exactly.
But-
So,
But courts have also, in 307 matters, the courts have compounded.
yeah.
No,
for
attempt to
example-
murder.
Yeah, correct. No, we had for medical cases, the section most commonly used is section 304A, that is causing death due to rash and negligent act. Now that also is actually non-compoundable, you know.
That's right.
But occasionally I have seen, you are quite right, courts are a little liberal at times. I have seen 304 also, the court allowing settlement, you know, even though it is a non-compoundable. So that one has to keep in mind that the court can say that this is non-compoundable, and whether you withdraw or mediate or do anything, the state is going to pursue the case, you know. So,
Yes.
but there are cases where they do relent, the courts. That you are right.
Okay. For those of you who, a lot of people have exited because we've crossed our time. This is a very interesting discussion. Thank you so much for attending, and we will continue this discussion and learn more about this topic in our training. The training details will be emailed to you, and you can also reach out to the Center for Mediation and Conciliation. You have the details for further information. I'm extremely grateful to all of you for attending. Thank you so much. Enjoy your Sunday evening.
Thank you. Thank you.
We look
It is
forward to
Thank
seeing
you.
Very-
Thank you,
very-
Gandha. Thank you so much.
very well conducted. Thank you.
Thank you.